We are recording. All right. So it's 2 after. I'm going to go ahead and get started, and it'll be a minute before Pia starts her presentation. So let's go ahead and get started. Welcome everybody to the January FABB meeting. Our guest tonight is Pia Miller of the Commonwealth's Attorney Office to discuss how the office handles bike crashes. So during the presentation, you're welcome to enter your questions into the chat. And then if you raise your hand at the end of her presentation, we'll try to get to the raised hands as well. We'll probably alternate between the chat questions and the raised hand questions, and we're going to try to consolidate any that seem like they're duplicates. And we had given Pia a couple of questions beforehand. So just for your knowledge, Pia has indicated that she won't be discussing specific cases. But so if you have questions that relate to a specific case, make it a general question so that she can kind of answer the substance of your question without getting into details. But before I introduce Pia, I wanted to mention a couple of things. First of all, thank you everyone who donated to FABB during our fundraising campaign. We ramped it up a little bit this year. Sorry for all the emails, but we very much appreciate everybody's support. It's going to help us be more effective this year in advocating and helping with rides, including the tours of the Hunter Mill and Mount Vernon districts, holding bike classes and all the other things that we do. So there's a lot going on this month. Right now, the Virginia legislature session is underway, and there are several bike-related bills. In Virginia, the Virginia Bicycling Federation tracks this legislation. They do an excellent job of it. They also hold a Sunday teleconference with advocates around the state, and they give updates on what's happening. And they also put updates on their website, which is vabike.org. So in this session, the biggest thing is that in Governor Northam's budget, he included $233 million for trails. The big struggle will be making sure that money stays in that budget and gets spread around the state. So that's what the VBF is really focusing on. There are a couple of other bills that are underway. The most egregious is SB 116 by Senator Norman, which apparently he doesn't like cyclists, especially cyclists who may roll through stop signs. So he's introduced a bill that would create a $500 fine for someone who rolls through a stop sign, and he would impound their bike for 6 months. So basically, this is a harassment bill, getting his political point across. It's not going anywhere, but VBF is obviously fighting that tooth and nail. And Senator Surville, who introduced the vulnerable road user bill last year, I think, or a year before, is trying to bring forth some clarifying language. So he has a bill, SB 247, that does that. And then this is a Senate bill trying to undo the two cyclists riding two abreast that was passed last year when a different party was in control of the House. So this year, this is a bill that's trying to reverse that, which we don't think is going anywhere. And also Senator Surville is trying to get additional funding for bike and bed projects through the Northern Virginia Transportation Authority and allocating a certain amount of funds dedicated to separate bike ped projects rather than having them be part of a road project. So that bill will be a struggle. So what I will do is I will put in, if I can make this work, the link to the VBF's, the Virginia Bicycling Federation's Bill Watcher spreadsheet. And I'm going to put that in the chat right now. And you can check this out. And it's a great asset. It provides regularly modified updates to what's going on in the legislature. And finally, wanted to announce that FABB has a corporate partner, our first corporate partner, and they are Bike Keep. Bike Keep is an international bike parking company. They provide secure bike racks and bike lockers, and they've started with several in the Reston Town Center. And so we're going to be working with them to encourage more people to bike to the town center. You know, it should be it's a very bikeable place. It's right next to the WNOD trail, but not as many people as should bike there. So we're going to be working with them to try to get more people out there biking. There are racks and locker that are activated through an app or through your smart trip card. So it's a pretty slick application, and it's free. So now on to the discussion with Pia. And to give you a little background, so after 5 years with no cyclist deaths in the county, last year there were 3 cyclists who were killed. In 2 cases, the drivers were charged under the vulnerable road user law. And in both cases, those charges were plea bargained down to lower charges. And so that's concerning to us. And you know, it could be that Senator Serval's proposed modification to the language will maybe address some of the reasons why that happened. But in general, we want to discuss that with Pia. So we want to know how that process works, because it's not real clear as far as, you know, just how the whole citing of a motorist or a cyclist, getting the charges passed over to the Commonwealth Attorney's office, and then having them review the charges and then prosecuting the cases. And so Pia Miller of that office is with us tonight. Pia is the Deputy Commonwealth Attorney for Community Justice. She received her BA from Northwestern University and a law degree from the College of William and Mary back in 2007. She then focused her solo practice on indigent criminal defense work, and later went on to work as a prosecutor in the city of Portsmouth. She was sworn in as the Deputy Commonwealth Attorney in July of last year. And in her current role, Pia serves as the liaison between the Office of Commonwealth Attorney and folks like us, citizens of Fairfax County. Pia's primary goals are advancing criminal justice reform and increasing diversity within the legal profession. She's working to develop a conviction integrity review unit, a conviction integrity review unit to review wrongful convictions. And she has a law student internship pipeline to increase diversity among Virginia's prosecutors. So with that, I will stop looking at my notes and hand it off to Pia. And I believe Pia is going to share her screen and go from there.
Well, good evening, everyone, and thank you for having me. Thank you for that introduction. I'm going to add in a few things and just say, yes, technically my job is to serve as the liaison between our office and everyone in the county. But I do feel like I am going to give you all, I'm seeing one of the questions that's already coming through the chat, and I know Bruce has sent me some other questions. I feel as though a lot of what I'm going to say tonight is going to tie directly into the next thing that I'm going to show you, which is our office has a very small bailiwick. We can control the things that we can control, and there's a lot of stuff that's outside of us that we don't have any direct control over. So if you hear me saying, that's not a question for our office, that might be a question for county police or for another agency. It's not because I am being purposefully evasive. It's because literally it's not something that we have control over. So with that being said, let me show you something that is not going to come through as clearly as I would love it to, but there's a reason for that. So can everyone see that? I'm going to make it a little bigger. Can everybody see that picture?
Yeah, I think we can. Yeah, I can see it. And if you could at some point maybe zoom in, that would be great.
Well, here's where I'm going with this. This is a whiteboard picture that I did another presentation for another organization, just as a very broad overview of the criminal justice system in Virginia. Now, this is more so in Fairfax County. We have various police departments, we have a sheriff's department, we have various investigative bodies. Smaller jurisdictions are going to operate differently. In Fairfax, generally, this is the rule for how criminal justice works here. Everything that is within the big circle on this picture is the stuff that our office actually has control over. The things that are occurring outside of the circle are the things that we don't have control over. And a lot of times people don't necessarily realize that part. And that's where things get a little bit interesting in terms of what we do as an office. Can everyone see this PowerPoint? I'm going to make this bigger.
Yes, I think we can see that.
Yes.
There we go.
There, good.
So with that being said, there's that lovely whiteboard picture again. I'm going to go through this really quickly, but basically you have 3 points of entry when we start talking about people being arrested or summons being issued, things like that. You're going to have eyeballs. So when I say that, what I mean is if an officer sees a crime occurring, or say someone is shoplifting in Target and the loss prevention officer calls the local police, that's eyeballs. You have a 911 call. So that say somebody broke into your home, you call 911, the police come out. And then you are going to also have police investigations. They're the investigatory body, not our office. Other offices may operate differently, particularly in smaller jurisdictions. And this is also, there's a very large difference between how state prosecutors' offices work and how federal prosecutors' offices work. But the police are the investigators. And so if they are doing perhaps a drug sting, that's where you're going to have investigations. All of those things are generally going to end up in some sort of arrest. When you have the arrest, you either talk about somebody being released on a summons, and that's, you wouldn't be arrested for your traffic ticket, but say you're speeding on 95, you get pulled over, you're written that ticket, that is what's called a summons. If you are actually arrested, you're going to be taken before the magistrate on a warrant. The warrant is going to require a finding of probable cause. The magistrate is going to determine whether or not you should be held for arraignment on the next date of court. In Fairfax, that's normally going to be the next business day. Or if you are going to be released on a bond that the magistrate sets. If the magistrate determines that you're going to be held, you will then go that box that says ADC, JDC, that's adult detention and or juvenile detention, just depending upon the person's age. In Virginia, juveniles are 18 and under, or 17 years and 364 days and under. Once you turn 18, you are an adult in Virginia. There is some legislation pending to kind of address that. I don't know that it's going to be successful this year. So this particular slide, I've broken it up this way to basically say, these are all of the things that our office is not involved in. So we get a lot of calls that say, hey, I want to drop the charges against this person. You know, I talked to the police last night and I had that person arrested and I want to drop the charge. We can't do anything about it because it doesn't even exist in our office yet. It doesn't exist until we get to arraignment. Once a person is arraigned, now their office, their case exists in our office. Again, this is how our office operates. Smaller jurisdictions may do things that are completely differently. But once that person is arraigned, they're going to be advised of their charge. They're going to be arraigned in one of the particular courts. So that's where you see the JDR, GDC, CCT for circuit court. Oh, I forgot that I have a touch screen. I apologize. So once you have those 3 courts, depending upon what your case is, so say it is someone who has been hit while they're on their bike, that's probably going to start in general district court. So that person would be arraigned in general district court. A trial date will be set. If it is a felony case, it will be set for preliminary hearing, and then it will go from there. So if you have a bench trial in juvenile court or district court, that's it. You will either be found guilty or you will not be found guilty. You can appeal it to circuit court, but that's basically it. If you have a preliminary hearing, your case goes to circuit court. You set it for a bench trial or a jury trial. You have your outcome. You're either found guilty or you're not. That's that arrow for sentence or acquittal. And one other thing that I'm kind of glazing over is preliminary hearing also leads to grand jury, which is another probable cause finding. Term day is where we actually set the trial dates, and then things go to bench or jury trial. Now, I have one of the questions that Bruce, I know you sent me, was asking about whether or not our office essentially brings charges, if we ever independently bring things. That would be a direct indictment. Direct indictments are not, I won't say that they're rare, but normally they are the result of testimony that comes out at preliminary hearing. So for example, we see this a lot, quite frankly, with our sex assault cases. So if our victim gets on the stand and says, you know, oh, he hit me on this day in this manner, and that was the sexual assault, like he hit me on a Monday, and then your victim gets up and also says, oh, and there was also this incident that occurred on Tuesday, then we may do what's called a direct indictment to add in the charge from Tuesday, when previously we may have only known about Monday. That is not, that's a very broad example, okay? It's not the only time that we would direct indict, but it is not the norm. And I will say that in terms of criminal justice reform and what's kind of happening across the state, is that there is more of a push to move away from direct indictments. And that's because direct indictments don't allow for the person who's accused of the crime to have the opportunity to be heard in district court at preliminary hearing. They don't know what evidence there is against them. They don't know anything about the charge. It just magically appears in circuit court, and it can be a little, depending upon the nature of the case and depending upon why that additional charge was brought, it can be a little bit more stressful than necessary had the charge just been brought initially. So with all of that being said, I'm going to stop sharing my screen because that's the last slide. Like I said, this is it. Yes.
Excuse me. Before you do that, well, you did. That's all right.
Oh.
We had a question about the difference between the general district court and the circuit court.
General district and juvenile domestic relations court. So GDC and JDR are our state's two district courts. Some jurisdictions have them jointly. Most of the time they're going to be separate, but they are two district courts. Those are courts of essentially lesser jurisdiction. They can hear misdemeanor cases and they can adjudicate misdemeanors to a final conclusion. So i.e. guilty or not guilty. They can hear preliminary hearings. They can address certain civil matters. So if you are a landlord who is suing your tenant, you're normally going to start in general district court. They have jurisdictional amounts. I believe it just went to 20 or 25,000. I apologize. I haven't done civil law in years, so I can't give you that exact number, but they, that's the difference. Circuit court is the court that's going to handle your felony matters. So the felony can start in district court, and that starting point is the preliminary hearing. So that's the probable cause determination. I like to, in my former days as defense counsel, I used to explain that as 51%. It's not an all out, you know, this person is guilty beyond a reasonable doubt. It's, is there enough evidence that it is likely that you are the person who was accused, that you actually did this thing? So that's where we as the Commonwealth, we're not going to present every single thing that we have. We do 51% basically to meet that probable cause determination. So that's the big difference between your district courts and your circuit courts. Does that, was there any follow up to that?
I don't see it. Thank you.
Okay. So with that being said, there is a lot, like I said, that is not within our office's control. And so when we get the case as a prosecutor, your first and foremost responsibility is to ensure that you are going to meet your ethical obligations. We ethically are not supposed to move forward on anything where we know we cannot meet our burden of proof. So what that means is when I was when I was still in a courtroom and doing more cases, I would get my initial file. You're going to look for your police report. You're going to make sure that you have your necessary witnesses. You need to speak to your witnesses. You need to make sure that they know when the court date is. Are they available to testify? Do they want to testify? We have a lot of people, and it's not necessarily in these accident cases, but it happens more so in, like, quite frankly, in the domestic assault arena, where you have other relationships that are going on and other things that are hindering people from wanting to testify. So that happens a lot. So you make sure that you have all of your things in place in order to meet your burden of proof, whether that's going to be a misdemeanor trial or a felony probable cause determination. If you don't have those things, you should not be going forward as a prosecutor. That's step number one. Step number two is you have to figure out what's going on here. How did we get here? And I say that to say, that's the point at which I would normally reach out to defense counsel. Hey, defense counsel, what's going on with this case? What can you tell me about your client? What can you tell me about any mitigating factors or anything that you are possibly thinking? And then we talk about whether or not a plea would be appropriate. So once I have done my diligence as a prosecutor and I know what evidence I do and do not have, and whether or not I can even meet my burden of proof, then I start talking about, okay, we need to either plead this case out or we don't. And there's a million little things that go into that, but that's a very general overview. So what else can I tell you all?
This is Cindy Englehart. The advocates in this area about 8 years ago, please correct me, Bruce, if I'm wrong, there was a large workshop in Arlington, and we had a lawyer at that, and he asked one question. There were about 100 people in the room. How many people had been hit by a car? And everybody but about me and one other person raised their hand. I think some of the basics that some people here would like to know is, where do they proceed after that? I mean, I understand there's different categories and different courts that you would go into, but a lot of this, in general, I think the advocates feel like they're not being heard, that there's an issue. So that's, if you could somehow or another address which court level that would be in. As you said, I think they don't have a burden of proof because apparently somebody would have been hit, and there are injuries, but that type of case.
Well, I think your starting point is always calling the police. So if you are, pulling out of Dunkin' Donuts and somebody hits you, you need to call the police. Don't just brush it off and keep driving and go home just because you're not injured or they're not injured or whatever. Because without the police, you're not going to have that initial accident report. And then also the police can come out and determine whether or not they're going to issue a summons for perhaps a reckless driving or a failure to pay attention or things like that. So that's really your starting point. After that, if you're not, and that, I say that to say that starts kind of the criminal track of litigation. If you don't want to do that track, I still suggest calling the police because you would still need that accident report from the police, because then you could talk to a injury attorney or a civil attorney about doing civil litigation. So if there was any damage to your vehicle, things like that, you would probably be filing your insurance claim, and then your insurance company is probably dealing with their own counsel to sue the person that hit you.
We're not talking about vehicle damage. We're talking about people that have become, as the phrases, people say I've been a hood ornament because they're hit by a car and they're vulnerable being a bicyclist. And the only evidence they may have is a GoPro camera that something happened to them.
Okay, if you're a hood ornament, you should still be calling the police. I mean, I don't know how else to say it.
Okay, thanks, Pia. If we could, from now on, if you could raise your hand, and then we will try to call on you, and we'll get at the questions in the chat as well. There is a question there. Pia, are you familiar with the vulnerable road user law? It hasn't held up in the first few cases that used it. Do you know why? And do you know what's needed to strengthen it?
I will say I'm familiar with the law. I don't know why it has not been more used or more successful. That is not a question that I could answer.
Okay. Then Jeff Gauger, go ahead.
Hi, yes, my question is with the vulnerable user law and also other laws like hit and run, I'm just wondering how you factor in for both pleas and for what sentence you're seeking deterrence. Like, I think the whole purpose of the vulnerable road user law is to, send a message about the need to respect the rights of vulnerable road users. And how does deterrence factor into your decision making?
I mean, I think, okay, let's take a deeper dive into when we start talking about making plea offers. The things that we are supposed to be considering: what is the defendant's criminal history? What are the circumstances around the incident? Do we have people who are willing to testify or not? There's a lot of little things that go into it. And thinking about whether or not we're trying to set an overall example by deterrence is not necessarily at the forefront, quite honestly. Because what we don't want to start doing is, if somebody is truly a first-time offender, and if defense counsel can explain to me, this was a complete accident, here's all the evidence I have to show that this was a complete accident, there's no malicious intent, this is somebody who has a perfect driving history, this is somebody who has a spotless criminal history, we're not going to, our office anyway, I can't speak for other offices, our office's policy is such that we're not trying to use that person as an example for everyone else. Does that make sense?
Well, so I'm wondering what about the big picture? Like, take hit and run, for example. It seems like there's been a lot of hit and runs recently. The big picture is you want people to stay, right? And isn't there some incentive on your part to, prosecute those cases to the fullest, to send a message that you stay when you get involved in the collision with someone? You don't take off and try to get out of it that way.
I mean, the difficulty with hit and runs is that normally there's also I call it a parallel civil case that's going on, because the insurance companies don't wait to do anything. And so what happens is, because there's parallel litigation going on, normally once the victim is made whole on the civil side, the criminal side kind of dries up. And that's not usually on us. That's usually defense counsel and the police saying, hey, this is kind of already resolved itself. So it's not as though we're shying away from making an example out of everyone, but that's also not necessarily the point of what our office does as it relates to prosecution.
All right. Let's see. Next question in the chat: how can we get court transcripts or basic non-party identifying information from plea deals on cases regarding car crashes or for educational purposes? I think if we could educate the public on past cases, we could raise awareness and perhaps develop better ways to protect cyclists.
So I have a follow-up before I answer that. To the person who asked it, are you trying to get like the actual wording of the plea itself? Or are you trying to get the conversation before the plea deal?
Steve Ward, I asked the question. I was just trying to get enough information to understand what had actually occurred very often. And just thinking of the past 3 fatal crashes in Fairfax County, is that we don't really know a whole lot about the situation beyond the basics. And, what ultimately was said in court and what was decided as to, as best as possible, the reconstruction of events were. I get concerned that a lot of times in discussing these things, one of the most common reactions is that, the driver didn't see the cyclist, the driver wasn't at fault, and some of that may be true. And I know these situations, as much as we care about the bicyclists, is that they're quite traumatic for the drivers. And, that's something that I hear a lot when I talk about this with people, is that, how awful the driver must feel. And I think if we had like written transcripts, or, how this played out in court, or how it played out in a plea deal, is that we could use some of that information as part of an educational program to kind of help people understand a little bit better, honestly, some of the stakes and why they should be driving more carefully. I don't want to go on too long, but I mean, it's been kind of shocking. I live in McLean, so when Matt Yeager was killed right after Christmas, I had a number of conversations with people who were saying, live in McLean, I'm regularly driving past that intersection near the library, and they were arguing with me as whether there was a crosswalk there or not. And I'm kind of like, yeah, there's a crosswalk. There's a painted crosswalk, and there are yellow signs. And they would make comments about it as like, I've never really noticed that. I knew there were the poles that, blocked people from turning right, but would allow them to turn left. And I think that's kind of a driver's attitude on a lot of cases. Like, they don't notice it unless it's right in front of them. And again, my hope is that if we could just get more information out about the events and what happened and what was really in play, it would be useful educationally to do that. So, I mean, are transcripts actually available? Are they public records?
So I'll say this, most of the time in district court, you are not going to have a court reporter because it's not a court of record. Circuit court is a court of record. So there is going, at least in criminal matters, you are going to have a transcript. If this is a civil matter that is resolved, they are going to have a transcript only if they hired a court reporter. Same thing applies in district court. So if they hired a court reporter, and a lot of times what I used to see is that the insurance company in the parallel civil case would have sent a court reporter over to hear whatever was going on, to hear and transcribe whatever was going on in the criminal case. Now, here's where, to kind of hopefully answer your question, the difficulty with that civil case pending and them sending over the court reporter is that that transcript is not part of the criminal case, it's part of the civil case. Does that make sense? And so because it's part of the civil case, it's not part of the criminal file. So I can't tell you, oh, that person's an adult, go on over to the clerk's office and follow their rules as to requesting the file. So before I move on to circuit, does that make sense?
Yeah, I mean, just the fact that there's not a record being made that's enlightening. I would have thought there would be.
No, that's another main difference between your district courts and your circuit courts. Circuit courts are courts of record, district courts are not. So that is why if you see a court reporter there, it's because they've either been appointed by the court on very specific, more violent felonies, or they have been retained specifically by counsel to be present in district court. In circuit court, you're going to have a court reporter on your criminal matters. At least on your felonies. I have been in courts where even though it was a misdemeanor docket, so say it was a misdemeanor appeals Friday, because they were misdemeanors, they're not required to have a court reporter present to transcribe those proceedings.
Okay, thank you. Are the hearings open to the public, or are they closed?
As long as they're adults, they're open to the public.
Okay, and where would I find court dockets published?
Courts.state.va.us. Now, well, that is for the rest of the state. I always, Fairfax, of course, is its own special little place, and Fairfax has its own court system, or, court case management system. So quite frankly, I would suggest just Google Fairfax case management. The misdemeanors will show on courts. Here, let me just type it into the chat. www.courts.state.va.us.
All right, thank you.
Pia, follow-up to that, the plea bargaining negotiations, do they make it to the court, or are those behind the scenes and not recorded?
They are not recorded. Judges it's the Supreme Court rules, and I think the judicial canons, their ethical rules, they are not authorized or allowed to participate in negotiations. So negotiations are strictly between Commonwealth and defense counsel.
Okay.
Or if the person doesn't have an attorney, it's with the person themselves.
So we could, in some cases, we've worked with the victims' families to try to get information, and that's where we've gotten what little information we've gotten in the past. We do have another question. Does your office play any role in educating the police department about the vulnerable user statute and when to charge that versus failure to yield?
Big answer, technically, yes, we could do a training. Short answer is no, I don't think we have done a specific training. I will say CA Descano, so Steve Descano is our elected official, has a very close relationship with Kevin Davis as the Fairfax County Chief of Police. And so that's the sort of thing where he may suggest to Chief Davis, hey, I think our office should give you guys a training. And that may also, now that I'm thinking about it, because I have to talk to Chief Davis on another issue, but it's something that should probably be clarified in their criminal justice academy for the recruits to make sure that because that's where the recruits learn all of their laws and what they can and can't write tickets on, things like that. And so if we make sure that it's part of their academy, and then kind of as perhaps a one-off course where we can just kind of sit them down. But the difficulty, of course, is there's a lot of them, there's a few of us. And so scheduling to ensure that we reach the entire department is probably not realistic. But if we could perhaps collaborate with them more on that, then we can certainly do that.
Now, that's something we have met with police, and we have advocated for more training, and they've mentioned the academy. It's very hard to get something into the academy because they have so much to cover in so little time, but that is something we could advocate for, is say trying to get your office to work with police on maybe a specific issue. All right. Alexis, do you see other questions?
There's a few comments. I kind of want to piggyback off of what Sonia had put in the chat about making examples and responsibility. Ms. Miller, because you mentioned that your office has, you said, a sort of policy of, if someone has a clean driving record, doesn't have any other criminal history, and for example, they hit a bicyclist while driving, there might be some consideration of the fact that they might, that they have this clean record. And so, you don't want to go around making examples of people. And I think in some cases that makes a lot of sense to not punish people. But, there's also this other aspect of, of being a responsible driver, of taking responsibility for actions when, you hurt someone. And so it was a little bit, I was a little surprised to hear that, it seems like there's some willingness to really let a lot of people kind of out of their responsibility to be responsible drivers, to be safe drivers and not to hurt people, even if they haven't hurt people before. When they do, I feel like there maybe should be a little more accountability.
I mean, like I said, the difficulty that we have to balance is do we put people in jail for a first offense that, for all intents and purposes, if they can prove it, was truly a mistake. Do we put people in jail for that? Generally, no. What they may end up with is a conviction that stays on their record that might be a misdemeanor or something that is going to be there. There are trade-offs. It's not a perfect system.
Of course, yeah, and I wouldn't suggest necessarily that everyone goes to jail or something, really extreme. But, we see in a lot of these instances, folks don't even really get a fine even, or their license taken away, or a suspension on their license. It's almost like the weight is swung completely on the other way. It's like, there doesn't seem to be a balance, right? Like, it seems like they're not being held accountable at all, in a lot of cases. So, definitely not advocating that people go straight to jail for years and years for something that's tragic and they have a clean record. But again, I think there should be more of a balance.
And Alexis, to just kind of add to that, there's so many car crashes. You could see where, if there's a car crash and it's someone's first time, and no one's injured or there's minor injuries. But with us vulnerable road users, almost any crash has major serious consequences for us. And I hope there's a different mindset in a car versus car crash versus a vulnerable road user. And I think that was the intent of Senator Surabill's bill, was to, almost regardless of who's at fault, if you do kill somebody or seriously harm or injure somebody, then there should be consequences, and it's a major misdemeanor. So anyway, that's my political statement.
I can move on to Frank's question unless Ms.
Okay.
Miller wants to respond to any of those comments. Okay. Frank asks if there's a public record of the Fairfax Circuit Court records and case status online and available to the public.
You have to sign up for an account. Like I said, Fairfax decided to be a special little flower, and the Fairfax Circuit Court records are not on the state court's website at the link that I previously provided. So I would just suggest Google Fairfax Circuit Court case management system, and if you choose to sign up for an account, then you would have access.
Do you think anybody can sign up for that account?
I believe you can. It's just you have to pay a fee. That's the difficulty.
Okay. Other questions? I've got a couple of questions, Alexis, if you do get to a point where there are no more, so go ahead.
We have a few comments. I'm not sure if they're for Ms. Miller or just comments in general. Yvette or Sonia, if you want to unmute and if you want to ask.
Yeah, I have a question in the chat that just said, could VDOT, for example, be held responsible for some of the pedestrian bike fatalities or even crashes that have occurred? So often the way that our driving behavior is pretty much what Steve was pointing out earlier, that people don't notice crosswalks or they don't pay attention to them, or speeding is not considered really a crime or anything like that. So the attitudes, the driving attitudes in their, where we are is just, it's all very prioritized towards driving. And also the way that the infrastructure exists, which is built by our Department of Transportation, doesn't really allow for safe roads for pedestrians and bicyclists. So have we ever seen anything where VDOT has been held responsible for this crash, especially if we're not willing to at all penalize the person driving?
I have not seen anyone suing VDOT, and I think that would, for lack of a better way to put it, I think that's above us. That would probably be an AG's office issue. And that's also probably more of a civil issue than it is criminal, quite frankly.
You're muted, Bruce.
Yeah, Pia, I do have a question. I had posed this earlier, And I think you did respond. It's regarding the police reports. Those reports contain a lot of good information when there's a crash. So they're required to fill out a report. It's called an FR 300. It gets sent to DMV. And in some fatalities, I have applied to get that report. And I think the law is, or a rule, I'm not sure which, only people directly related to the case are supposed to get the report. But I've filed for it and they've actually sent it to me. I've paid my $15. And I think the reason why others can't get the reports is because there's personal identifying information. So your response to that was that we could go through a FOIA. Do you know if through FOIA I could get any crash report?
So I'm going to give you a very lawyerly non-answer because I can't give you legal advice and I can't tell you what to do. But I would suggest that FOIA has very broad range. Submit your request and see what happens.
Okay, that's kind of what I did with the asking for the report. I kind of knew that I wasn't supposed to get it, but they gave it to me anyway. But we would really like to work with police to try to, look at these reports, work with them on figuring out maybe why something happened and go from there and have that information more widely available. And it doesn't have to be tied to the people involved. But so anyway, Alexis, any more questions in the chat?
Yes, from Cindy, and this ties back to a question, Bruce, that I think you may have sent earlier about video evidence. Just in general, if a cyclist or whomever gets video evidence of a driver behaving badly, harassing, or causing damage, whatever is on the video, if there's video evidence, can they get a driver prosecuted?
Respectfully, Cindy, that's the wrong question. The question is whether or not you could get charges. So you would need to contact the police, show them your evidence, and then they will make that determination.
You're correct. I do not have a good terminology on this field, but
Okay.
That was one of the complaints that I would get sporadically in my previous position, was that, in fact, ironically, one of the bicyclists that was harassed found out that it was his student's teacher at one point. And so he didn't want to, ruin the guy's life, but he was trying to figure out some way of getting him to understand that it's not cool. It's somebody's life you're risking when you're harassing.
Yeah, and I think police have said that they will take any kind of information like that, and it could be presented to them, I think. So Pia, I want to follow up now on the vulnerable user charge and plea bargain. So I guess kind of in general terms, if someone's charged with the vulnerable user law, which is I think it's a second-degree misdemeanor. Anyway, it's more than just a minor misdemeanor. And they also failed to yield. So there could be two charges. They were charged with the VRU charge, and then it got plead down to a lower charge. In general, what do you think would be the main reason for that?
Hey, generally, I would say it's a matter of the civil litigation has probably already taken care of everything. So that's like if there were medical bills or damages that needed to be repaired, things like that. That's usually a huge driving factor, is what's going on in the civil side. And then second is probably, I hate to kind of put it on them, but are the officers available to testify? That's a huge issue as well, because unfortunately, we as an office don't have control over the officer schedules. And if an officer is not available for that particular court date, and really, quite frankly, the only thing that we would need them to testify to is to the actual crash report. It's an authentication issue as to whether or not we can introduce it, things like that. It's a technical issue for the lawyers, but really we need them to testify to that. And if they're not there, and that's a missing piece of our evidentiary burden, and the judge is not willing to grant a continuance, then we're looking at that. The judge may say, I'm not going to grant your continuance. Counsel, do you all want to step out in the hall and maybe come back with another request? And that's when we might step back out in the hall and talk about, okay, I've got a victim who is here and they're good, but I can't meet this missing piece of my evidence. And so I'm going to offer you this plea. Like, that's another huge factor.
Okay.
And the same thing goes for if my victim wasn't available for court to testify, hey, this is the injury that happened to me. This is how it happened. This is what I suffered. If the victim calls me and tells me, Pia, I've got COVID, unfortunately, we do have some situations where continuances are being denied because of that. And so that's a situation where, my victim may very well make it clear, Pia, I would love to go forward. I just can't because of this. And so then I'm going to defense counsel and I'm like, hey, here's a plea offer.
I think that the problem that I see with having it settled on the civil side is that those penalties for drivers, like, I don't know, under the vulnerable user law, that misdemeanor penalty is pretty serious. And even though they may have had their insurance may have had to pay for various damages and so on, they're still driving around. And if that charge is lowered, then it's not on their record. And I see that as a problem. But that being said, you did mention the crash report, and that was one of the questions we asked earlier. We had been told that crash reports were not submittable to courts, and we understood, and we also heard that they may be, depending on, I guess, certain factors. Your response to that question earlier was that yes, they can be. Could you maybe just comment on that?
I would just say, again, all the stars aligning, you have all of your necessary witnesses, you have a crash report that is complete. It's the original document. It's not a photocopy, because there's other evidentiary rules if we start talking about photocopies and things like that. You have your officer who actually wrote the report and investigated the scene, because what also happens a lot is, say 2 officers respond, or say 2 vehicles respond. One person may be like the rookie officer on scene, and so they were told to just do the paperwork, but they didn't actually look at anything. Then we as prosecutors don't know that until the day of court, when that rookie shows up because they got the subpoena and they're like, but I didn't really do anything. They just told me to write these things down. Yeah. So I'm saying that to say, if all the stars align and we have the things in place, there is not a reason why it can't be used. Now, I will say, sometimes they're helpful and sometimes they're not, because we also get into whether or not someone's handwriting is clear, whether or not the report is properly, or whether or not the accident itself is properly documented. Because I remember I had a situation once where it was a hit and run, and it was pure property damage. So a parked car had been hit, in front of the house, and the way that the report was written was literally like backwards in terms of where the car had been hit. And I looked at it and I was like, I can't use this because it's not right. Like, it literally doesn't match what's written in the actual police report. So there's all sorts of little things. Now, what's more helpful are pictures. And, a lot of, especially here in Fairfax County, a lot of our officers are going to have body worn camera. They're going to have cameras that they bring on scene, and they actually take pictures. That's where we really get the most helpful evidence. The written reports are great, but they're not perfect.
Thank you. Sounds like a training opportunity there to make sure they get it right. Alexis, any other questions in the chat?
I don't see any questions, just comments about some documents that folks can obtain from police departments, and comments about civil trial. A comment from Mike Doyle about, in general, civil trials are being postponed versus criminal charges are being handled relatively faster. Is there anyone who's had a comment or question in the chat, or otherwise wants to raise their hand and unmute and speak?
Okay, Mike, I see you literally raising your hand. and
Yeah,
the
right. I
other hand.
didn't know if
Okay,
I could get it quick enough. I'm
there
sorry.
you go. Good, thanks.
Yeah, thank you. So first of all, thanks for doing this. I'm sorry I'm late. I'm trying to get in. Yeah, the civil cases are being deferred significantly. And in the vulnerable road user, which we help to advocate for down at the Transportation Committee and other committees with Senator Surivel, that has seemed to be diluted by some of the, or at least some judges in some areas, not every place, are taking, they don't take it as seriously. So there are some current drafting of the bills of the vulnerable road user that's in session now. And if you or your office had some suggestions of how to strengthen that bill, for example, right now it focuses on pedestrians and there isn't enough clarity about cyclists. So a new amendment to make it include cyclists. But that's just one aspect. The question is, why isn't it really carrying some weight and some consequences? And I don't know the answer. I'm not a lawyer, but I do know that people, it was put in because there was, a driver could kill somebody and get $250 fine. So this was, other than reckless driving, this was sort of something in between. That's why it's there, but it's not working. So we'd welcome your thoughts of how to strengthen it so it would actually hold up in court, besides all the mechanics of what you talked about of how to get it to trial and all that. But the actual law itself, it seems to be less than perfect. Thank you.
Well, here's where I'm going to, again, give the very lawyerly non-answer. There are certain pieces of pending or proposed bills that our office is vocally in support of, and everything else we are not commenting on. I would suggest to continue working with Senator Surivel. He, as you probably know, is an attorney. He is very attuned as to what happens in the courthouse and what does and doesn't work. And so keep working with him if you feel like changes are necessary, and keep those conversations going.
Pia, a quick question for you. If you are prosecuting a case and you need a little bit more investigation as to what really happened, sounds like you reach out to the defense attorney and others. Do you ever do outside investigative work or contract for any additional? No. No.
What would happen is in terms of asking defense counsel, I'm only going to ask defense counsel for things about their client specifically. So, hey, is there anything mitigating that you want to tell me? If I have a question about something that perhaps occurred on scene, or whether or not there is video footage or things like that, I'm reaching out to the actual reporting officer and I'm saying, hey, could you, your report references that there might have been a camera at this street corner. Did you have an opportunity to pull the footage? And if so, could you provide that footage to me? And if you haven't done it, can you go get it? That's the sort of thing. But we as an office do not investigate, because that would make us witnesses.
Right. So, but you do rely on the police, and there's some back and forth once they've kind of put it over on your side.
Yeah.
All right. Great. So Alexis, if there are no more questions, I don't see any other hands raised. Are there any others questions?
I don't see any in the chat.
So Pia, I think one last question would be, do you have any advice for us as advocates to try to make sure that cyclists, are safe, and that drivers, become more responsible for their actions that harm cyclists? I know it's a very broad kind of general question.
I mean, I hate to kind of put the onus on the bicyclists, but we have so much technology these days, and GoPros are so, GoPros or some variation thereof are so easy to obtain that I think anything that you can do to help yourself is like the best you can get at this point. Unfortunately, as I'm sure most of us know, our police department is overworked and underpaid and very much understaffed at this point. So, and that's not to say that it's okay, but what we are seeing and what we're hearing is people will call the police, and if the police come out and they're like, you don't really have anything that I can use, I'm just going to keep it pushing, you know, good luck to you, glad you're okay. That's unfortunate. And unfortunately, they don't have the resources to really, or the resources or the time, quite frankly, to dig much deeper because they're very much understaffed. Now, if we could have the perfect world where everybody is fully staffed and everybody's fully paid and there isn't COVID and people aren't scared to be on the streets, that sort of thing, that's a different conversation. But I think until those things improve, the more that you can help yourself to give to your officer is very important. And going back to what I said a few minutes ago, call the police, demand, I don't know, I saw it in the chat, someone said that they personally advocated for themselves. Like that is the biggest key here. If you can be your own advocate, have your own documentation, show that to the police, that is the biggest first step. Because, and quite frankly, make sure that the police take that information from you. Because if you haven't given it to the police, then we have evidentiary chain of custody issues that we might have to deal with as the actual prosecutors. So give it to them, you know, keep your own copy, give them a copy, but make sure that you are documenting everything that you can and make sure that you're contacting them. Don't brush stuff off, don't leave. I would also say to continue to advocate your localities in terms of if you feel like if it is an unsafe intersection, that you need to be talking to, you know, if it's a Fairfax County thing, you need to be talking to the Board of County Supervisors. If it's the town of Herndon, you need to talk to them. Like, do the things so that everything is documented and everything can hopefully be addressed in an adequate manner.
Yeah, unfortunately, in the past, I have and others have gone to the police, given them the information, and it's been basically he said, she said, and they don't do anything. But I have learned that we can go to the magistrate's office and ask them to record this, to make a report and provide information to them. And I guess they can then, in that case, I assume they would decide whether to move forward or not. Is that correct? You know,
the magistrates, ow, dang, I just hit my knee. The magistrates can issue what's called a citizen's complaint. And that's on certain misdemeanors and a handful of felonies. But that is also a possibility.
okay. Yeah, I have two cameras, one in front and one in back, just for that reason, because I know that my word isn't much, but if I've got it on video, that certainly helps. Well, Pia, thank you very much. It looks like there is something popped up in the chat. Do we want to take a quick look or not? Subject to some specific risk. This is generally what they're. No, it's too much for me to read.
It's the outline of what can be requested from the like the police department, things like that.
Okay,
So
great. That's great. Then Alexis, can you make sure we save the chat so we get that information?
Yes.
And I will not end the meeting before we do that. Well, Pia, thank you very much. We really appreciate you taking the time. And I hope you get those vulnerable road users charges that will stick in the future because our lives depend on it. So thank you for what you're doing. And thank you for coming tonight. And thanks everybody for being here. We will make sure we get the word out about the next meetings. Now, Jeff Gogger has his hand raised. Or is that an applause?
That's clapping.
Oh, all right. And same with Alexis, got a thumbs up. So, all right. Thanks again, Pia. Appreciate it.
thank you, everybody, and everybody stay safe and have a great night.
Okay.
Thank
You
you.
too. See ya.
I got the chat saved, Bruce.
Okay, good. Thank
And I
you.
will stop the recording.